Hi everyone, my name is Swathi, and today we're going to be talking about the insanity defense. And here is everything we're going to be going over today. So, to start off with, what is the insanity defense? Before researching this topic, I mostly associated the insanity defense with famous media cases and movies. But after reading more, I learned that the insanity defense is actually very rare. It's highly misunderstood and involves extremely detailed psychiatric evaluations. I also learned that public stigma and misconceptions about mental illness strongly influence legal outcomes. And so to clearly kind of define what this means, it's essentially a legal defense claiming that a defendant was unable to understand their actions due to severe mental illness that they experienced during the crime itself. And just so you guys know, NGRI means not guilty by reason of insanity. That's a term that's probably going to be coming up quite a lot in this presentation. So, the insanity defense is a legal defense that's used in criminal trials when a defendant argues that they were unable to fully comprehend their actions or distinguish right from wrong because of a severe mental illness during the crime itself. So, if the defense is successful, right, the defendant may receive a verdict called not guilty by reason of insanity or NGRI. And so, one important distinction is that mental illness alone does not automatically qualify someone for insanity defense. A person can have schizophrenia, bipolar disorder, depression, or another mental illness and still be considered legally responsible for their actions. The court focuses specifically on the defendant's mental illness during the offense. And in many insanity defense cases, courts examine whether the person understood what they were doing and whether they understood that their actions were wrong. Another important point here is that the insanity defense is actually very rare, as we just talked about, and it's successful in only a very small number of cases that are criminal. And many people believe that it's actually commonly used, but research shows that this is clearly inaccurate. And so some important cases are listed here that are notable and are quite important for, just to know more about this, which I will be going into. So the article that I used for this presentation, it's by, excuse me if I mispronounce their name, but it's Hangyu Bresch, basically discussed how psychiatry became closely connected to the legal system during this period. And so one important issue was whether someone could appear normal on the outside while still suffering from mental illness internally. And several famous cases that are legal also shaped modern insanity defense standards. Excuse me if I mispronounce this person's name, but the McNaughton rule created in the 1800s became one of the most influential legal standards for insanity because it focused on whether a defendant could understand right from wrong at the time of the crime. Another major case was the John Hinckley Jr. trial after the attempted assassination of President Reagan. And after Hinckley was found not guilty by reason of insanity, there was strong public backlash, and many states actually tightened their laws that were about the insanity defense itself. So, overall, the historical development of the insanity defense shows that public fear and public opinion have actually influenced how courts handle mental illnesses in cases. So, one of the biggest themes across my research was the role of public perception and stigma. Many people understand that insanity defense and believe that criminals frequently fake mental illness to avoid punishment. But the research shows that insanity pleas are actually extremely uncommon. Another common misconception is that defendants who receive NGRI verdicts are simply released back into society. But in reality, most individuals are placed into psychiatric hospitals or treatment programs and remain under supervision. One article also discussed the concept of sanism, which refers to prejudice or discrimination toward individuals with mental illness. And media coverage often portrays mentally ill offenders as extremely dangerous, which increases fear and stigma. But these misconceptions matter a lot because public attitudes can, heavily influence jurors, people who make laws, and even legal policies that surround mental illness and criminal responsibility. Two of my studies focused on jurors make decisions in insanity defense trials. The research found that jurors are often influenced by stereotypes and emotional reactions rather than purely objective reasoning. The study by George examined whether different types of delusions influenced verdicts. Participants were given fictional trial scenarios involving defendants with paranoid delusions uh, or no delusions. And the study found that jurors reacted differently depending on the type of psychosis shown and whether the defendants appeared visibly psychotic in court. Defendants who appeared paranoid or visibly mentally ill were actually more likely to receive insanity verdicts because jurors viewed them as, more mentally impaired. Similarly, another study by, excuse me if I mispronounce this person's name, but Moisier and Maidier examined the effects of defendant gender and mental illness type. The researchers found that defendants with schizophrenia were judged differently compared to defendants with substance abuse disorders. And so this kind of shows that gender stereotypes also influence the opinions of jurors. These studies show that stigma and misunderstanding about mental illness continue to shape criminal trials, even though courts are supposed to be objective. Many jurors may still rely on stereotypes about dangerousness, um, psychosis, and criminal behavior in general. So a key point here is that bias and stigma influence legal outcomes. One of the most articles that I read was the study by Brown and Wood. Um, and this basically examined different subtypes of insanity defense cases. Um, the research, the, analyzed 187 court-ordered forensic evaluations involving defendants whose insanity defenses were supported by evaluators. The research found that insanity defense cases are not all the same. Instead, they identified several common subtypes. One major subtype, as listed here, is called paranoid self-defense, where defendants committed crimes because they believed that someone was trying to harm them due to personal delusions. Another subtype involved the protection of others, where defendants believed that they needed to protect another person because, again, of delusional thinking. The study found that psychotic disorders were very common among successful insanity defense cases. So different psychiatric symptoms were also linked to different types of crimes. And, this research is important because it shows how complicated insanity defense evaluations can be. Mental illness affects behavior differently, depending on the individual's symptoms, delusions, and psychological stats. And so, one thing that really surprised me during my research was learning what actually happens after a successful insanity defense. Many people kind of assume that defendants are immediately released. That's what I thought, at least, but this is not usually true. The study by Rogers and Wettstein followed individuals who had received NGRI verdicts and were placed into outpatient psychiatric treatment programs. The researchers examined which symptoms were linked to relapse or rehospitalization. The study found that patients with severe symptoms such as paranoia, delusions, suicidal thoughts, and, you know, other types of paranoia were more likely to relapse and require rehospitalization. And so this research shows that the legal system focuses on treatment and supervision after insanity verdicts very, very heavily. Many individuals continue receiving psychiatric care for long periods of time. And this also connects back to the public misconception discussed earlier because NGRI usually involves continued monitoring rather than freedom without consequences. So, the current system. Overall, my research revealed several major problems with the current insanity system. And one major issue is juror bias and stigma surrounding mental illness. Several studies showed that stereotypes strongly influence decisions when it comes to making a verdict. And another issue is inconsistent forensic evaluations. For example, Brown and Wood explain that insanity evaluations can vary significantly depending on the evaluator, which, may create inconsistencies in court. There's also a lot of tension between psychology and the law itself because psychology recognizes is extremely complex and that it may not always kind of align with the law itself. Um, and what I mean by that is that, well, because it's like the legal system prefers mm, categories more and simple answers about responsibility. And so public misunderstanding continues to influence policy decisions and public trust in sanity defense system. Based on the research that I reviewed, there are several possible policy improvements that could make insanity defense cases fairer and more consistent, which is what we want, right? So, first, courts could improve juror education about mental illness and psychosis, since many studies found that stereotypes affect verdicts. Better education may actually reduce bias. Secondly, forensic evaluations could become more standardized in order to reduce inconsistencies between evaluators. And thirdly, increased mental health training for legal professionals could actually improve understanding psychiatric disorders in courtrooms. So, expanding psychiatric treatment and kind of monitoring programs could actually improve long-term outcomes for individuals and GRI while also protecting the safety of the public. Overall, these reforms could balance fairness, mental health treatment, and criminal responsibility for the defendant themselves. And just some main takeaways here. The insanity defense is, one that is stood, especially when it comes to criminal law. And so my research showed that it actually is very rare and involves extensive psychiatric evaluations and treatment systems. The studies also demonstrated that public stigma or bias in media portrayals strongly affect legal outcomes in trials. At the same time, though, courts continue struggling to balance scientific understanding this with legal definitions of criminal responsibility that they are supposed to. And ultimately, a fair legal system must balance public safety and legal knowledge when evaluating the defense cases. So, yeah, I hope that you guys, learned a little something about the insanity defense, and hopefully there are some that happen in the real world in order to make the system operate more um, fairly. Uh, Thank you so much.